Yeah, yeah, yeah. So many lies that you hear from the net, they don't get her respect. She reporting the truth, not a check. You want an unbiased opinion straight from the chest, not a bit accomplice or someone here for a check. Tune in, these are thoughts from a lawyer on a mission who goes so hard it's like she works on commission. Trolls in the comments might say she tripping cause they lack the knowledge, they don't know they missing. Got a couple current events that you like, wanna know about law from the eyes. Tired of all these blogs running lies because their agendas are disguised. Tune in to the intellect, cause I'm sure y'all missing all the facts of the case that she steady is gifting. Someone here for the people, man, it's so uplifting. If you ain't subscribed yet, then you just omitting facts.
Hey y'all, we are back. My name is Pam Esquire, also known as Your Law Intellect, and we are here to talk about Diddy. It looks like Diddy will be appearing on Friday, so if you have your plane tickets, your bus fare, your train tickets, they are still good for Friday's hearing for the sentencing because Judge Submaranian has denied his motion for acquittal and for a new trial. One of the things I told you all after the hearing last Thursday is that I believed he already knew what he was going to do. That's how I felt. And I also said that I doubted very highly that he was going to grant these motions. But shout out to the Dream Team for putting in that work and fighting vigorously for their client, because that's what you are supposed to do, even though some of y'all want people to just fold and say, I did it. I did everything they said. Shout out to the defense attorneys that are out here defending, because some of y'all be ineffective. So we're just grateful for that. So anyway, that's what we're here for. We're going to get into that order and opinion. Okay, focus. We're going to get into that order and opinion. But yeah, well, it's a no. Judge said, nice try. Good arguments. You get an honorable mention. But it's a no for me, bro. See you Friday. That's the short summary of what went on. So let's pull up this document, y'all. J Love said, yeah. I didn't think he was getting off on it. I didn't think he was getting acquitted. But hey, the senator said that don't look good. He's about to get the book thrown at him. That ain't looking too good either. The sentencing is when he got acquitted of the main charges, I'm not even going to lie, I really did think that the sentencing wasn't going to be as big of a deal as it is, as they made it. Like I didn't. I thought, okay, he's probably 2 to 4 years or something. He's already done a year. Get on, supervised release, time served from the commitment aspect of it, and move on. No, the government has found every nook, cranny, and possibility to enhance that sentence, asking for 11 years. Kelly said, yeah, not surprising. No. Shout out to the defense attorneys out here defending known criminals. Oh, gosh, Pam. Do you want to, Pam? Do you want to put this out here? First of all, I'm going to generally say this because this was very ignorant. The reason why I'm saying it's very ignorant is because everyone has a constitutional right to have a defense. Okay, that's the first thing. So read your Constitution. The second thing is everyone who is accused of something did not do what they are accused of. Therefore, they are not criminals. They are accused of doing something or committing a crime. Thirdly, people are wrongfully convicted for the same mindset. People always believe that because someone labels you says that you committed a crime, that you did it, and they don't care until it happens to them. or happens to their son, happens to their daughter, then all of a sudden you want to blow my phone up. Didn't you say, I mean, my child wasn't even there. Didn't you say you do wrongful convictions? I want you to help. I'm like, no, remember everybody's criminals who the police say are. Remember that? So this ain't the platform for that. Generation old school. You really are old school, and that comment was ridiculous. All right. So you got addressed on tonight in a very nice way, because really my first instinct was to be a bit more meaner, but I'm not. I'm working on it. So from earlier to now, my allergies just started tripping for always forever. I don't know. I took a Zyrtec, so I don't know how long that, like I said, I'm not going to be on here too long just because I don't know when that medicine's going to kick in. But yeah, I am a little stuffy, but it's more of allergies. I've just been sneezing. Once like 5 o'clock hit, I've just been sneezing the whole evening. I don't know. I don't know. But that is that. Andre said the judge is sending a bad example of men she doesn't know, Sean Combs. Hey, Mom's the boss. Lois Cobb said, I think it's unfair the jury found him not guilty of violating the Mann Act while he's still in jail. It reminds me of giving OJ a large sentence for stealing his stuff since he didn't get hired for murder. And I was going to bring that up earlier because I kind of felt that way about OJ. When he got that acquittal, they was good. We got our eye on you. So you do have to be careful when you are acquitted or convictions overturned, because I think you do become a target. And I agree, because what did he do, like 10 years? They gave him some nice football numbers for stealing his own memorabilia back. It's like, oh, we didn't get you that first time over there in California, but we getting you over here in Nevada. You said Diddy will be dancing again. Don't know the year though. Yeah, he won't be Harlem Shake him today. He won't be Harlem shaking up out of there today, according to Judge Submarinians. Judge Submarinians say, nope. Good. Hi, Hood Mayor, New York. It's good to see you. So let's pull this up. All right, let's pull this up. Thank you all for joining. Please hit the like button for your girl so that we can get in that algorithm for those that ask why I always ask that. So this was just filed. After an 8-week trial, a jury convicted Sean Combs of 2 counts of transporting people for prostitution under the Mann Act. Before the government rested its case, Combs moved for acquittal under Rule 29 and Federal Rules of Criminal Procedure 29. The court reserved its decision under Rule 29B, and Combs renewed his motion after the verdict. He also moved for a new trial under Rule 33. For the following reasons, both motions are denied. Give a little background. We're not going to read everything. It is 16 pages, but as you see, it's not double spaced. Okay. So it's a lot to read. So we're gonna hit these points that we went over last week when we went over the tweets and the arguments. The government first indicted Combs on September 2024 for violation of the Mann Act, for trafficking, and for racketeering conspiracy. Excuse me. In its third and final indictment, the government's case was built on Combs' actions beginning in 2004 and continuing over the next 2 decades. The government alleged that Combs arranged for and paid men to travel across the United States and internationally to have sex with Combs' girlfriends, Cassie Ventura and Jane. Further, the government alleged that Combs transported Ventura and Jane to have sex with those men, gave them illegal drugs, and physically abused them. This, the government argued, was all the product of the Combs enterprise, a criminal organization comprised of Combs, his businesses, and his employees. On the government's telling, that organization existed for lots of reasons, not only to run a global business in the media, entertainment, and lifestyle industries, but also to fulfill the personal desires of Combs, particularly those related to Combs' sexual gratifications. This case went to trial. After the government rested, the Combs moved for acquittal. That motion focused mostly on racketeering and trafficking, but also contested the Mann Act charges. With respect to the Mann Act, Combs argued that the escorts who testified didn't travel across state lines, but they disavowed that they were paid for X or engaged in prostitution, that they sometimes were paid even when they didn't have X. The court withheld its decision and the charges went to jury. The jury agreed with Combs about the trafficking and racketeering, acquitting him on both, but it disagreed with Combs about the Mann Act, finding him guilty. Combs now renews his Rule 29 motion and also moves for a new trial under Rule 33. So then they go through the legal standard. So then we're going to get into the discussion. Hold on one second. I got to grab some tissue before, 1 second, guys. Thank you so much for your patience. So these are the arguments that Combs proffered on in the brief and then reiterated on specific points when they went to argue it last Thursday. The Rule 29 argument is the motion turned on what the word prostitution means in the Mann Act. The act has two clauses. Both share the same act element, transporting somebody to interstate or foreign commerce, but they have different intent requirements. The first clause, the one at issue here, requires that the defendant intend that the transported person engage in prostitution. The second clause, a broader catch-all, requires that the defendant intend for the transported persons to engage in any sexual activity for which any person can be charged with a criminal offense. So they say together they read, whoever knowingly transports any individual in interstate or foreign commerce or in any territory or possession of the United States with intent that such individual engage in prostitution or in any sexual activity for which any person can be charged with a criminal offense. At trial, Combs proposed that the jury instructions define prostitution as, quote, engaging in sexual activity for money or its equivalent. The court adopted Combs' definition in its instructions to the jury, which proceeded to convict Combs under the definition. Combs changed his mind. Now he argues that his proposed definition was wrong all along. So they used the definition that he gave, and now he's changing his definition for purposes of this argument. Prostitution, he says, instead, requires either that the defendant have a commercial motive, that the buyer have sex with the seller, or both. That would mean that there was never any prostitution involving Combs, who lacked a financial motive and didn't directly have sex with any of the men he hired. On his telling, applying a broader definition would create constitutional problems. These arguments don't hold water for the reasons below. Judge said don't hold water. So first of all, there was an issue on whether he forfeited or waived the challenges, and the judge basically said no. So that was the first argument. That he didn't waive it. Then the court says Combs' newly proposed definition of prostitution is wrong. Combs argues that prostitution, properly defined, has two elements absent from this case. First, the defendant must have a financial motive. Second, the exchange of money for sex must be bilateral. Whoever pays for the sex must engage in it. Both arguments share a similar structure. Each posits that the definition of prostitution at the time of the Mann Act's passage was overbroad in some respect. Then each suggests a way to narrow that definition to avoid potential constitutional problems. If Combs is right, then his convictions, even on an alternative theory like aiding and abetting, should be reversed because no prostitution occurred at all. But both arguments fail. Combs got it right the first time. Said when you asked for the definition for the jurors in your jury instructions, you was right the first time, but this time you're wrong, okay? The correct definition of prostitution in the Mann Act is sex in exchange for money or its equivalent. And that definition poses no constitutional problem. Number one, prostitution means sex for sale. To any modern reader, the plain language of prostitution is sex for sale. Every modern dictionary the court consulted says the same thing. So they done looked up prostitution in the Oxford Dictionary that said the practice or occupation of engaging in sexual activity with someone for payment. They looked up the Merriam-Webster. It said the act or practice of engaging in sex acts and especially sexual intercourse in exchange for money. They looked up the Black's Law Dictionary, the 12th edition from 2024. The practice or an instance of engaging in sexual activity for money or its equivalent, commercialized sex. The Mann Act's history doesn't suggest that a different definition applies. True, in 1917, the Supreme Court indicated that prostitution as used in the statute could be, quote, for hire or without hire in U.S. v. Caminetti. And that's a 1917 case. So that was like way long ago. And that appears to reflect how the word was used at the time. It defined prostitution in 1910. The Black Laws Dictionary defined prostitution as common lewdness and whoredom. So when they called you a whore, that meant you were a prostitute. But the court walked away from that expansive definition 3 decades later in Cleveland v. United States, recognizing that prostitution normally suggests sexual relations for hire. And while Cleveland didn't explicitly overturn Caminetti, its definition of prostitution was key to its reasoning that debauchery differs from prostitution in the statute because debauchery doesn't require payment. That was the Supreme Court's last word on the matter before 1986. Then in 1986, Congress amended the Mann Act cementing the common sense definition of prostitution. It struck the entirety of Section 2421 sub A and reenacted it, reinserting the prostitution clause, but cutting the law's anachronistic features like the debauchery and immoral purpose provisions. And then it has the House history documents, it looks like. Child sexual abuse and pornography. Okay, let's go down. To think that Congress instead wanted to revert to Caminetti's expansive definition of prostitution disregards the entire purpose of the amendment. It eliminated provisions that have been criticized as Combs criticizes them now for their alarming scope. So, consistent with prostitution's ordinary meaning, how the Cleveland court understood it, the judicial state of play when Congress last amended the provision, and how Congress would have understood the term at the time of amendment, the right definition is the one Combs proposed at trial, and that the court used in its jury instruction: engaging in sexual activity for money or its equivalent. But Combs isn't satisfied with that definition. He says that prostitution has 2 additional requirements, neither of which is grounded in the text of the statute. The meaning of prostitution at the time of the Mann Act and Act's enactment in 1910, or its meaning when the statute was amended in 1986. For the following reason, the court rejects Combs' proposed additional requirements. Second, a defendant need not have a financial motive. Combs first argues that prostitution in the Mann Act requires that a defendant have a financial motive. There's nothing in the text of the statute to support this requirement, and it doesn't make any sense in this context. Combs wasn't convicted of prostitution, but rather transporting others for prostitution. Combs seems to be conflating 2 things: the definition of prostitution and the motive of the defendant who transports somebody for prostitution. The statute requires only the intent that the transported person engage in prostitution. Combs' argument imposes an additional mental state requirement for the transporter and grafts it into the word prostitution, a word that by itself doesn't contemplate anybody but the parties involved in the sex act. What happened in this case was transportation for prostitution, even under Combs' understanding of the term. Combs transported the escorts who were financially motivated and intended for them to engage in prostitution. Whether Combs himself was financially motivated never enters the calculus. There's no basis to adopt Combs' proposed financial motive requirement for defendants in the Mann Act cases. So basically, he's saying go up to Congress. Take it up to Congress if you want to add some additional requirements in order to satisfy the Mann Act. A bilateral exchange of money for sex is not required. Combs also argues that prostitution is strictly bilateral transaction. One party pays the other for sex, then those same two parties have sex. That definition would narrow prostitution almost out of existence. It would exclude any situation in which a person pays a third party, like a brothel, to have sex with an employee. Remember, he mentioned brothel in this whole exchange on Thursday with his hypothetical. So that's why I said he already pretty much knows what he's going to do. But he let them come duke it out and argue and let them say, this is an embarrassment to the United States government. They should be embarrassed. To support that narrow construction, Combs invokes a series of state court decisions that he says adopt his definition. Putting aside that none of these decisions interpret the Mann Act, the government points out, these cases aren't good evidence of the meaning of the word prostitution. To the extent that these cases are relevant, they stand only for the proposition that states have defined prostitution differently within their statutes. So then they got a bunch of different cases in different states from which they define prostitution. Combs argues that these cases show that prostitution requires a bilateral exchange of money for sex. Not so. Judge said, These cases involve the question of whether there's prostitution when there's no sexual contact at all between the participants. That isn't at issue here, given that there's no question that Ventura, Jane, and escorts had sex. The cases didn't address whether prostitution requires the bilateral exchange of money and sex between only those participants, as Combs insists. And even if they were relevant, these cases didn't turn on the bare word prostitution, but instead on the definition provided in each statute. The second group of cases concern strip clubs and commercial voyeurism. A few of these cases simply aren't relevant. Basically, he's saying the case law you get to support yourself. When I say, what is your authority? You ain't give me no authority, okay? They're not relevant. So then he says, well, there are two other cases in this category that appear more relevant on first blush, which means there's a second blush of which he changed his mind. All right, and this is State v. Wooten, State v. Taylor, and Wooten v. Superior Courts. All right, courts in Arizona and California confronted the setup of a theater or club where a customer would pay to watch employees touch each other sexually. And Taylor, the Arizona court, held that the charged employees who engaged in the touching with another dancer was legitimately prosecuted under Arizona's prostitution statute, which requires sexual conduct with another person. That was so even though the defendant didn't pay the other dancer, undermining Combs' proposed construction. And just as in Burgess, the Arizona statute made clear that the fee arrangement could be with the person engaged in the sex or any other person. So that case also cuts against Combs. Next, let's go on to Wooten. The California court held that the purveyors of a similar club weren't involved in prostitution. Unlike Taylor, a combination of the statutory definition of prostitution and prior case law led to the conclusion that California statute was not written sufficiently broadly to encompass a sexual transaction for a customer who engages only as voyeur. That's the conclusion that Combs would have. This court reached for the Mann Act as well, but he doesn't explain why the definition of prostitution in a California statute and interpreted by a California state court should control the definition of prostitution in a federal statute. That problem is exacerbated by the array of definitions used by the states. Why should one control above all others? Indeed, in Wooten itself, the court observed that Wisconsin courts had adopted a broader interpretation of that state's law that would include instances where a third party paid for the sex, such as businessmen paying someone to have sex with his client, demonstrating that these state decisions are state specific. We're federal over here. Don't be throwing us state case law as your authority. I'm gonna need you to come back over here to interpreting this federal statute. That is what Judge Submaranian basically said about those cases. Finally, in People v. Paulino, a New York trial court addressed the challenge mounted by a purveyor of sex for hire to his conviction for promoting prostitution. The New York law at issue, he argued, should apply also to pornographers, and because it wasn't enforced against pornographers, his case was selective prosecution in violation of the Equal Protection Clause of the 14th Amendment. The court rejected that argument because it would eradicate the traditional bilateral notion of prostitution, which entails A paying B for sexual activity to be performed on A. The court isn't persuaded by this interpretation. So that is pretty much what was argued on Thursday on what they're saying what prostitution is. And it is kind of how we generally interpret prostitution, where it's A pays B for sex, to have sex with A. And they're saying, yeah, that's nice and all of that, but we're not persuaded. We're not persuaded by that either. It cites no authority for its assertion that this is the, quote, traditional definition more generally. Paulino instead begins with the premise that pornography simply could not be covered by the definition and works backwards to explain why some of its reasoning rested on the definition it divined from the New York authorities, while other parts rested on the premise that a corporation enjoys First Amendment protection while brothel doesn't. And then they go on to say, because they say, well, it's unconstitutional if you decide to keep defining prostitution like this. So the court goes on to talk about how defining it in the way that it was defined to the jurors is not unconstitutional. Please hit the like button, y'all. Thank you so much. I appreciate that. Mo Better said he needs a new judge. This lets me know Friday isn't going to go well for Puff. I don't know. You never know. Maybe he'll split the baby or something. You know? You said it's complicated. Yeah, he still got Trump too. Maybe he'll tell Trump he's sorry. Maybe he wrote him a letter and told him he was great. He's a great guy and he's sorry for everything that he said. And could he please forgive him? A pardon is his last hope. The judge feels his crimes are very serious. That's from TJ. Me Cheese too said this judge is confident in his bias. I wouldn't be surprised if his direction is coming from Trump on some get back. Oh my goodness. Christine said, I don't think he's going to do 11 years though. I don't either. I'm thinking less, but he's going to do some time. I'm kind of with you. Diddy should thank God he was not guilty of the other charges because the judge would have buried him. You might be right, Robert. Aubrey said, let that man go home to his family. You would think, but he's Diddy. So I just wonder if it were other people that were not Sean Combs, how would he be treated? If it wasn't as publicized, if we weren't talking about it, if you didn't have people camping out in tents all night long trying to get into the court, would it be handled the same way? So Jay Love said, I'm not a Diddy fan, but this all seems extreme. It's a bit excessive. I agree. J Max said this judge is totally against Diddy. I think he may sentence him to 47 years. Wow. All right, let's go on to his other argument, because we're not going to talk about, they said that they believe it's constitutional. So that's going to really be boring and put you to sleep, because they're going over substantive due process and federalism. Okay, but let's get to the First Amendment. Okay, now this was the argument that kind of had us on the edge of our seat. We was like, oh, I thought it was creative. But you did, I'm kind of the opinion as well, you can kind of see how their arguments somewhat evolve. And see, that's one of the things the fact that he had this case happen so fast, when you can't sit with a case. Because a lot of times I'll write a brief and I'll have my arguments, and then I'll sit down for a week and sit it to the side, and I'll come back and some other things that I need to add ends up being added to the motion, or some things that another way to say it, or maybe this argument is better than that argument. Or believe it or not, sometimes I'm talking to y'all on here and something you say in the chat, I'm like, yeah, that's a good way to think of that. And I can incorporate that and tweak it. So you have time to sit and marinate. I think a lot of stuff with Diddy, even though he had a lot of lawyers, is it happened so fast. So even when it came to the request for bond, I think his attorney Agnifilo felt like he was prepared, because they knew this was coming since what he said about February or March of 2024, before he was arrested in September. And he was trying his best to negotiate with the government for his surrender. And he said, I have the passport and I have the family's passport. He's going to move here so he don't have to be he was trying to find a way to have him come as a celebrity through the back door where it's not a big deal. But this is a big deal case. And this is a case that would have been, this is considered a career maker case. That's why the government looks so bad, because you really did kind of lose, like, okay, you did get the Mann Act, which has some years to it, but I think they're really going hard on it because the bigger cases that they wanted, they obviously didn't get. For those that watch the show on Hulu, Reasonable Doubt, that's my joint. Comes on Thursdays. And the season that they have now, they just started. One of the things was it's a celebrity that she's representing, and she was able to kind of negotiate and make sure the bond was together, and all that stuff was talked behind the scenes. And that does happen sometimes. Celebrities or non-celebrities, you can talk behind the scene. I just feel like for this case, they didn't want to have any type of quietness. They wanted it to be as big, just like when the raid happened. How the cameras already there? How were the cameras already there? Then you had Damian Williams did this whole press conference with guns on the table, and this was a whole production and performance. He's terrorized for decades, and we're gonna get him. Now, he was gone before the decision was made, but those were the people he put in place on this case, and he's the one, that was his administration that brought this case. So, yeah, I think they're just having a hard time taking that L, but again, it's just my opinion. You said we should do reasonable reaction segments. Him getting any time is complete BS. It's racist as F, and the people so concerned of hating him, they are missing it. Trump and every man in America needs to be locked up for buying P, jail for that. I would hate to see some of the skeletons in the closets of some of our greats, like our musicians. He didn't invent this. Diddy did not invent this. Somebody told him he could get away with this. This is right, something he was introduced to, something that happens in Hollywood. Like, it's things like this have been going on for decades. And half of your music shelves will probably be deleted if you knew all of the stuff that some of these people did. He just was going to be the poster child. That's all. And so, yeah. And then you get people, these letters, man, I don't know how to feel about them. And people get mad. Like, the internet is a place where people can have their own opinions. And people really get mad and come for you like you're some promoter of domestic violence, or you're a promoter of drug use, or you're a promoter of this, because you respect the juror's decision. Just like we would have had to respect the juror's decision if they said it was a RICO. I'd have been like, oh man, this is a slippery slope. And he probably would have appealed. But at the end of the day, I mean, that's what you can do. Y'all want to respect the jurors' decision after they saw everything. They saw videos. They saw a lot of this stuff we had redacted. They seen stuff that we didn't see. We only saw part of the evidence. We didn't see all of it because some of it was under seal. So we didn't even see the entirety of the case. So they saw everything, come to an opinion. And then when you try to respect their opinion and say, well, we're not going to try to get them on the back end with the sentencing, then what if it's your mama? What if it's your sister? He been doing this to people for years. Okay, but that's not what he was convicted with of. If he had been doing this for years, and I said this over and over again, 20 years ago, 30 years ago, you should have went to the police. Or you should have did something within the statute. But it is unfair. There's a reason why there is a statute of limitation. Things get stale. Evidence gets stale. People die. Like, it's hard for you to defend yourself the longer it is. So that's why you have statutes. People get mad, but that's the purpose of statutes. Because how you going to defend stuff and you don't even have the evidence anymore? Or you can't show where you were at that time when they say you were here. You can't show that you were here. The thing about celebrities, though, that I noticed, even with Jay-Z, because they're out and about so much, in the Jay-Z case, he was able to show where he was at. There were photographers that he was able to contact to get pictures from back then when he was accused of the situation with Jane Doe. They have, even with Diddy, he was able to show he was on a Bad Boy tour. He was able to get information because he used the same hotel, so he was able to go back in time. But a lot of this stuff gets stale, and we don't like live our lives to think we may have to present this in front of a jury for an alibi. We don't live our lives like that. So that is why there is a statute of limitation. And then people that's like, he's just as arrogant, he's never gonna learn. I mean, you're basically saying there's no hope, and I don't think that's fair either. If this did not scare him, when that man was found not guilty on those first 2 charges, what did they show you on the sketch? Him getting on his knees. Because I'm sure while he was sitting there, he was ready to pee his pants, trying to see if he is going to spend the rest of his life in prison or not. If this didn't scare him, I don't know what would. Just saying. They went to the police and some were ignored. Well, we didn't see that in the case. So I don't know. I didn't see no police reports in the case where they showed that everybody was ignored and all of that. I've heard all of y'all on the internet. I've heard people say it. Nobody has really given names like that on who these people are that went to the internet. Like, what we did hear is that there were 2 times. One of the reasons why Cassie's friend is not friends with her anymore is because she called the police when Cassie was getting beat up. And I think she got hit by Diddy, and the police came and she wouldn't give her ID and she didn't want to press charges. Apparently there was another time of which there was an altercation where somebody called the police and she didn't want to press charges. So that did come out in the trial. Kids ain't going nowhere, Kalonda. I'd have been, if I was his daughter, I'd be like, what I got to do with it? I can't go to Canada. I can't go to Niagara Falls. I got to stay on the New York side because you got in trouble. Like, what? What I got to do? Even the baby. They even gave up Baby Love's passport. Everybody got. You get your passport taken. You get your passport taken. Everybody got their passports taken. Robert said they went to the internet police. They went somewhere. Well, Gina didn't show up, so I don't even know what you're talking about because Gina was on the list and she didn't come. So what I'm saying is the jury is not, they're admonished not to get on the internet. So all of this fluff and conversation that you guys have on the internet about what you think he did this to me in 1965 and all of this stuff, that was not the evidence in front of the jurors. And I think people just really have a hard time with that because they feel like, why didn't the jury believe all these people that have nothing to do with this case? Does that make sense to you? They can only focus on and make their opinions and their decisions on the evidence that was rendered admissible in trial. They can't even, if I, as an attorney, tell you to think some way about a piece of evidence where the government is saying it mean this and I mean this, they'll tell you it's up to you, because what we say as attorneys is not evidence. Evidence is those individuals that took the stand. You get to weigh the credibility on how much weight you put on the evidence. They may not have put much weight on a lot of the evidence, a lot of the people that were put on there. That's what happened with the RICO. The RICO charge was mainly a lot of the people that you saw on there where there weren't individual charges about. You had Kid Cudi, like you had all these different incidents. All of that was RICO. Nobody's saying that he was the greatest person. I think he has to acknowledge that he wasn't ish. You know? I think he has to acknowledge that he wasn't the greatest of people. Nobody is saying that. It's like if you say that you are a person that's like, okay, this is the rule of law and this is what it is, and this is in respect the juror's decision, then all of a sudden you in bed with Diddy and you just a groupie and he paying you or something. It's the craziest logic to me. A jury found him not guilty on 2 of those counts. I mean, what else do y'all want? Coach B, thank you for the super chat. She said, thank you for assisting us in learning both sides of the law in layman terms and examples. Thank you so much for supporting the channel. I appreciate that. Kelly said, I think accountability can go around to all of them. Well, apparently that's the biggest argument too in the chat when people, I think it was on the Shade Room, people weren't all just pro Cassie when they put her statement up there. And some people are like, so when are they accountable? But then you get people that have been abused and they're like, you don't understand the trauma. You don't understand the psychological abuse. You don't understand the cycle, so they want you to understand in everyone's head why they did that. So apparently they don't believe there is accountability for them because they were under some type of manipulation or psychological abuse where they shouldn't be accountable. And that is why you have Michelle Brannon in that David E. Taylor case, who was the co-defendant, who was saying, I was a victim of manipulation too. I wasn't his right hand. I was doing what he said. So that's what I'm saying. When does it end? When is it going to end where you can just say, I was manipulated? I have to take accountability. I don't know. But apparently in this case, again, nobody was charged with him. Most of them got immunity. Most of them got immunity before they testified, so they're not coming after them. So there's that. And Michi too said logical over emotions is a tough one for people. Yeah. All right, let's get into the First Amendment argument. It's always good chit-chatting with y'all. Thank you all so much for sticking around. The First Amendment, Combs argues that because he's an amateur pornographer and consumer of pornography, his conviction violates his First Amendment rights. That argument fails for 2 reasons, according to Judge Submaranian. He said, first, Combs' conduct is not protected by the First Amendment. First Amendment protection applies only to conduct that is inherently expressive. Conduct is inherently expressive if there's both an intent to convey a particularized message and the likelihood was great that the message would be understood by those who viewed it. Though film is an expressive medium protected by the First Amendment, at some point it must certainly be true that otherwise illegal conduct is not made legal by being filmed. So they have case law that says you can't make things legal by filming them. And the same goes for the desire to view pornographic performance. At some point, illegal activity can't be laundered into constitutionally protected activity just by the desire to watch it. Combs' conduct goes far beyond that point. Evidence at trial showed that when Combs filmed, he didn't typically give notice ahead of time or ask for consent as a film producer would, and that he masturbated, suggesting that the purpose was his immediate sexual gratification. In fact, He sometimes participated in the sexual activities. The evidence showed that Combs and the escorts would both have intercourse with Ventura at the same time. And after Ventura or Jane finished having sex with an escort, Combs would have sex with Ventura or Jane, often while the escort's semen was still on their body. At other times, Ventura would put the men's semen on Combs, usually on his chest, on his nipples. Combs' incidental filming resembles the facts of Arcara v. Cloud Books, Inc., in which a bookstore could be shut down to combat the prostitution happening on its premises. Even though that restriction affected the distribution of pornographic materials, the shutdown didn't implicate the First Amendment. The court underscored the fallacy of seeking to use the First Amendment as a cloak for obviously unlawful sexual activity by the diaphanous device of attributing protected expressive attributes to that conduct. In concurrence, Justice O'Connor emphasized that any other conclusion would lead to the absurd result that any government action that had some conceivable speech-inhibiting consequence, such as the arrest of a newscaster for traffic violations, would require analysis under the First Amendment. Against that, Combs relies on 3 state court cases. None moves the needle, so he's not moved. First is the Paulino case from New York that was discussed earlier. Yes, the Paulino court worried about the consequences of extending prostitution laws to commercial pornography, but Combs didn't engage in anything resembling the adult film distributor that Paulino assumed would be shielded by the First Amendment. Recall that Combs doesn't bring a facial challenge, but instead only challenges the statute as applied to him. That means that just as Paulino confronted a factual situation far from the core of any protected activity, so too does the court. The other 2 are cases where prostitution convictions were invalidated based at least in part on free speech considerations. In People v. Freeman, a California Supreme Court case, they held that a California statute on prostitution would violate the First Amendment if applied to a pornographer. And State v. Therault, a New Hampshire Supreme Court case involving a defendant who paid to videotape sex between other people. But in both cases, the court's free speech concerns arose from the fact that the defendant's purpose was to film a performance, not sexual arousal or gratification. That isn't the case here. They said, Mr. Combs, you weren't trying to perform. You was actually trying to get gratified. So it's a no. Second, even if Combs' conduct falls under the First Amendment's protection, his conviction doesn't violate it. If speech is implicated, then the Mann Act is a content-neutral restriction that has an incidental effect on speech. Such restrictions are analyzed under the O'Brien test. All right. So anyway, under the O'Brien test, it's a no too. So that's the second reason. Then they say there was sufficient evidence to convict under the definition adopted. Combs' fact-based challenge also fails. He argues that the evidence wasn't sufficient to convict him under the definition of prostitution used at trial. To sustain a conviction under the Mann Act, one of the dominant purposes of the transportation must be for the transported individual to engage in prostitution. It need not have been his only purpose or motivation, but it must have been more than merely incidental. Combs' argument all sound in the same tenor, that even if he paid escorts and they had sex with Ventura or Jane, he didn't intend to pay for sex at the time of the interstate travel. Instead, he meant to pay only for their time. That's what the escort services do. If they end up having sex at the time, I mean, and even if that was foreseeable, it wasn't the object of the transaction. To support that framing, Combs argues that the evidence at trial showed that sex was never part of the bargain. He points to evidence that the agencies that provided the escorts didn't advertise themselves as selling sex for money. Instead, they offer time and companionship, or alternatively, dancing and stripping services, but not sex. During the negotiation, Combs wasn't privy to any of the details other than what are we doing and who's available. One of the escorts wouldn't have thought twice to think that it was prostitution. Another, who massaged Ventura, was there only to create what he called a sexy scene. At least one of the escorts also had sex with Ventura without payments and felt romantically attached to her. Finally, Jane and Ventura sometimes describe the escorts are entertainers paid to entertain. The problem for Combs is that the court defers to the jury's choice of the competing inferences that can be drawn from the evidence. And a great deal of evidence supported the competing inference that a dominant purpose of the transport was to pay for sex. Y'all want to hear that evidence again? I'm sure you guys heard it at the trial. So now we're going to go over the evidence that the judge says support the facts that the dominant purpose of the transport was to pay for sex. Please hit the like button. Thank you so much. Subscribe to the channel. We would love to have you over here. First, evidence at trial showed that both parties to the transactions acted as if they were engaging in prostitution. Each side worried that the other side was undercover police, a concern that wouldn't be relevant if Combs' intent hadn't been to pay for sex. At least one escort asked Combs whether he was a cop, and Combs had Ventura ask multiple escorts the same. So then they go to the transcript. Quote, "Hey, are you a cop?" Ventura says, "Sean wanted me to clarify if the person was a cop." And Combs believed that the escorts were frequently being tested for sexually transmitted diseases as part of their job. Jane said, "He just said, why wear a condom? These guys are safe. They get tested all the time." Second, Ventura testified that the escorts were paid to ejaculate and to have sex with her, contrary to Combs' contention that they were paid for their time and companionship. Question: for the escorts who you interacted with, what were they paid thousands of dollars to do? The answer: to ejaculate, to finish. Question: for all the dancers you interacted with, what were they paid to do? Answer: to entertain and to also ultimately have intercourse with me. Even the escort that Combs claims testified that, quote, he wouldn't have thought twice to think it was prostitution, explicitly stated that he was paid money for sex and wasn't paid when he couldn't sexually perform. Question: what did Cassie Ventura give you money for in around 2012? Answer: to have sex with her. Jane testified that multiple men were routinely paid by Sean after they finished having sex with her. Third, their compensation was tethered to their performance at their job. Quote, when escorts ejaculated without having been told to do so, Combs wasn't pleased by their performance and they would take less money. And fourth, even though some escorts also spend time with Ventura and Combs outside of sexual activity, others engage in sexual activity on every single trip with both Ventura and Jane. Question: every time you met with Miss Ventura and Mr. Combs, what was the purpose of the meeting? Answer: to have sex with Cassie. Question: Jane is a typical hotel night. How would intercourse with an entertainer end? Answer: with them finishing on me. Question: at the end of each hotel night with Cabral, what, if anything, did you give to Cabral? Answer: money. Combs' other arguments fall flat. This judge with the flat, fail, don't hold water. Yes, much of this evidence comes from after the escorts travel, but is still relevant and probative of Combs' intent beforehand. And to be sure, some of the escorts may have had mixed motives, as Combs points out, but the evidence still supported that Combs intended to pay the escorts for sex and that the escorts indeed had sex and got paid. Finally, even if the government relied on some circumstantial evidence, it also presented direct evidence in the form of Ventura's and Jane's testimony, and in any event, a jury's verdict may be based entirely on circumstantial evidence. There was also sufficient evidence admitted at trial to interstate transport of escorts of Ventura and of Jane for paid sex. For this reason, Combs' argument that the escorts who testified at trial didn't themselves travel between states isn't ground for granting relief. So now he gets into the Rule 33 and says no new trial is warranted. This is the last argument in the opinion by Judge Submaranian. Aubrey said, we need to be protesting to get them people evicted from the White House because DJT is going to have, goodness, Aubrey, you trying to get me a little blocked over here with that type of conversation. He brought up mental illness. He did bring it up, and it was redacted that he's had some mental health challenges over the years, and that was part of the sentencing. That is why Dante Nash tried to say, well, he had it before and he still did it. That was the point. A lot of the stuff he said before was because he was allegedly taking medication. They said he was over medicated and he was on drugs. Now, obviously, he's been in jail for a year, so he hasn't been able to have access to drugs, and he probably has the right amount of medication that he needs for his mental health. So he is probably in a different state. He probably thinks clearer, and he actually has to sit with himself, and he has to sit with the things that he has done. Back then, when you're high all the time, and then you got people to handle whatever you want to handle, it probably was less probable that there would be any accountability or change because of that. But now you actually have to sit with people. He's going to walk out those doors and he knows you were once just loved, where people was geeked to have you around. And now you got to reinvent yourself. This is going to be a whole different life for him. Let's keep it real. Second, send the dots until they say no. Well, I don't know if anybody said no. I didn't see that happened. They just said they really didn't want to do it, but they wanted. Jane said, I wanted to please my partner. So she never said no. She just said she wanted to please him. So she put up the show that she liked it, but really in her mind, she really didn't like it. But she never told him no. Cassie says she would say things like, give him hints. I got a UTI. I got sores in my mouth, things like that. And she was saying he didn't care. He still was like, but are you still up for the free cost? And she would do things to please him because she loved him. So everybody has pretty much acknowledged, those two, by everybody, have acknowledged that they did this stuff in order to please him. So, yeah. Let's go on. Let me see. Christine said rehabilitation is the key. Wonder if he entered programs while he's in there. That makes the difference in sentence. Yes, apparently he has. And of course, like I said, now there is a difference between you being in jail and don't have access to the drugs and you being out and having access. So he would need to have that treatment regardless. You can be clean, but you're almost forced to be clean while you're in there, because he was caught with the pink powder when the place was raided, and he knew that he was there because he was going to be arrested. He just thought maybe he was trying to live it up. And they said he had heels, and I guess Jane said she was supposed to come and meet him at the hotel he was staying at. So I don't know if he was trying to get his last hoorah. I don't know what was happening at that point, but yeah, that's it. So let me go to this. So you telling me, I want you to show me in this transcript, and then I'm going to stop addressing you, because I already addressed you in the beginning and I see what you over here doing and you aggravate me. But what you're saying is, show me in the transcript where she says she told him no. she didn't want to do a freak off and he beat her up. Show me any place in the transcript of which that says. And the reason why I say that is because this is why they did sex trafficking, because they wanted to try to connect the dots. What you're saying is exactly what the jury did not find for sex trafficking, because that's coercion. You making me do it. So that means you're inferring that you know that there were times in the past where she said, I don't want to do a freak off, and he mollywopped her. That's what you're saying. Her just making the statement of, I know what he would do to me. Well, you have to have a reference that she may have generally just been talking about he beat me, period. There's a difference between beating you for not having a freak off. Now, he might have popped you regardless, because he was the domestic violence abuser. That's different than what they're saying with sex trafficking. That's why they tried to connect it with Jane. Remember, Jane tried to say 2 months before she got mad at Diddy, she took his head, slammed it on the table, and then he forced her, like he beat her up, they had a fight, and then he forced her to engage. They were trying to say that's sex trafficking because a lot of the other ones seemed like you were consenting. And then the same thing with Cassie. They showed the video over and over again. First of all, because they knew we would be disgusted. The video of the beating in the hallway by the elevator. You knew we was going to be disgusted when she got kicked and hit in the head and all of that stuff. They knew that. But they tried to connect it to a freak off. She testified that it was after they had already done it, and she wanted to leave so that she can be nice and refreshed for her. I think they were like, she had a movie or something on, and they had press day. So yeah, that just be aggravating me. Anyway, Christine said he never said he's gonna beat her up if she didn't do it. Now, did he beat her? Period. Yeah, we seen evidence that, and even him saying she took his phone. I'm sure he was pissed that she took his phone, because she probably was trying to look to see who else he was banging or whatever else he was doing, if that was true. And it doesn't give him a right to put his hands on her. But that's when he got mad in general. It sounds like he might have hit her like she was a kid. That's why she said things in text messages like, I'm somebody's child. You won't want nobody to do your kid like that. All of that in the text messages, because he would just get mad at things she had done. And you can tell by the text messages when he was like saying some of the things that she does and seem like she tries to provoke him and all the stuff he used to say in the text messages responses. But that is separate and apart from if I did not do the freak offs, he is going to beat me. That is what they were trying to establish for sex trafficking, of which the jury did not agree with based on the evidence that was presented. That's all. That's all there is that. All right. So you're not getting any more conversation from me tonight. And I'm serious. So you can say whatever. No new trial is warranted under Rule 33. Combs says that he should get a new trial under Rule 33 because his RICO and ex-trafficking counts shouldn't have been joined together with the Mann Act counts. The evidence introduced to prove the former, he says, spilled over and prejudiced the jury against him on the later. These challenges are difficult to prevail on. As a general matter, a Rule 33 motion should be granted only with great caution and in the most extraordinary circumstances. And on top of that, a defendant arguing prejudicial spillover bears an extremely heavy burden. A court considers, 1, whether the evidence that related to the dismissed charges was of a type that would incite or arouse the jury into convicting the defendant. Number 2, the similarities and differences between the evidence related to the dismissed charges and the evidence related to the remaining charges. And 3, the strength of the government's case on the remaining counts. The government argues that these factors shouldn't come into play and that Combs' argument should be summarily rejected because there's no precedent for a new trial based on retroactive misjoinder following a split jury verdict. Putting aside whether that's correct, Combs disagrees. It's certainly correct that Combs is asking the court to find retroactive misjoinder in an unusual circumstance. He says that the evidence that was introduced on the RICO and sex trafficking charges prejudiced him on the Mann Act counts, but he was acquitted on the RICO and the sex trafficking counts. So his claim is that the jury was prejudiced against him because of the evidence of racketeering and sex trafficking, but still didn't find him guilty of those same counts. He's missing the word find, Judge. You're missing something in that sentence. As Combs concedes, the Second Circuit has never found spillover prejudice when the jury acquitted the defendant on the allegedly prejudicial charges. That's for good reason. The absence of such spillover is mostly readily inferable where the jury has convicted the defendant on some counts but not on others. When the jury was able to distinguish between counts or between defendants and assess separately the evidence pertinent to each, there's no basis for concluding that a new trial is warranted. As a result, the typical articulation of retroactive misjoinder is that it kicks in only after later developments, such as district court's dismissal of some counts for lack of evidence, or an appellate court's reversal of less than all convictions render the joinder improper. Nevertheless, the court declines to summarily reject Combs' argument without reaching the test. Applying the relevant factors, Combs fails to carry his heavy burden of showing spillover prejudice. The court takes the factors in reverse order, starting with the third, the strength of the government's case. As described earlier, the government at trial presented overwhelming evidence of Combs' guilt under the Mann Act on many occasions with respect to both Ventura and Jane. That evidence consisted of testimony from Ventura and Jane, testimony from the escorts involved, and evidence from text messages and emails. The government proved its case many times over. So he's saying under the Mann Act, the government proved this case over and over and over and over again. That by itself might be enough to dispose of Combs' challenge, but the other factors don't do much to help Combs either. He concedes that under the second factor, if the inflammatory evidence would have been admissible anyway on a separate trial for the remaining counts, then the claim of spillover prejudice likely fails. That narrows any factual challenge to evidence unrelated to the Mann Act charges, like arson or forced labor, to give a few examples. But on the first factor, it isn't at all clear that the evidence worked to incite the jury to prejudice Combs. It weighs heavily that the jury declined to convict him on any of the counts related to that conduct. Had the prejudice indeed been so great, one would expect the jury to convict on the most relevant counts before it could spill over and infect the others. A new trial is not warranted. For these reasons, Combs' motion under Rule 29 and 33 is denied. Dated September 30th, 2025, which is 3 days before his sentencing. And that's that. Dale says some of you guys need a hug. Let me give you a virtual hug. Jesus loves you, this I know. Okay, now it's hard for some people when they don't. I guess I argue every day against people that don't agree with what I say. And so sometimes they can persuade me, but you have to have authority for what you're saying. And then sometimes I concede. I've conceded in arguments before. I'm like, all right, Judge, I'll leave it to your discretion. I ain't got nothing. I don't have anything. And sometimes they laugh like it is what it is. And sometimes I'm going to fight like Diddy's team, and I'm going like, no, I really believe in what I'm saying, and you going to hear what I got to say, and we going to peel this mug all the way up to the top. So, yeah, that's what it is. But I did well. I didn't block anybody. I think I did pretty good today. Sentencing, I don't know what time the sentencing is. So if anyone finds out when it is, please DM me. And make sure you all are following me on Instagram and TikTok, Pam ESQ. Okay? Trying to, go to some other platforms and do some things when I have to do some quick lives. But yeah, that is the entirety. Of course, we skipped some stuff because it was like 16 pages, single space. So that is the entirety of the opinion. Thank you so much, DC Lively. I appreciate it. Love Breezy said it's at 10 a.m. All right, it's at 10. I was actually going to try to go, but our schedules between me and Dev is so busy all the time. So I wasn't going to be able to finesse this one. I was like, I could at least go to the sentence. It's October 3rd, 3 months in advance. It seemed like September was pretty busy. October's pretty big. November is just full. In December, I try not to do too much because that's, it's around the holiday. So, and a lot of judges take their vacations around that time as well. So they don't like to, after a certain point, they don't really like scheduling trials. They're not going to schedule certain hearings, all of that. So, yeah. So anyway, y'all, I'm out of here. You guys have a good night. Make sure you like the live, subscribe to the channel. I enjoyed all of you guys. And I hope you guys, learned a little something, can look at things in a little different way. Or heck, you may have said, girl, you ain't changed my mind. It is what it is. I think he should go down for everything. And you're entitled to your opinion. I would just respectfully ask you find some authority for some of your opinions so you can have some persuasion if you want to be a person of change out here. Don't just say any old thing. That's all. Pastor Diane White said, but if he wasn't diagnosed before he went in, it probably won't help. He was diagnosed before he came in. And Cassie actually spewed a diagnosis. I don't know if that is what it is, but she said that she did say that he had a mental health issue that she knew about, that I think he may have taken medication or wasn't taking medication. I don't know, but she did testify to that. But within the actual document, because they were going, if they were going to put on a case, they had people waiting to put on a case. And it was contingent on how they felt the government did and who they planned on putting on the case. After they cross-examined everybody and kind of dismantled and poke holes, they didn't feel like they needed to put on the case because of course, you're not trying to put your client up either unless you just have to put your client up. That's not anything you want to do. And so they didn't. And one of the people was going to be, I believe, an expert that was going to have some explanation as far as his diagnosis, the medication he was on, how he was being overly medicated, allegedly. And then he was taking all these different street drugs as well, and how that bad combination. This is why the people from Making a Band and all them was like, why he ain't want us to sleep? Like, this is why. You guys weren't taking things to stay up and not get rest. And he was taking all type of stuff that was keeping him up. So there's that. All right, y'all, before my nose start running again. I really enjoyed myself tonight, and I hope you guys did too. And we'll be back at least at minimum on Friday for the sentencing. If anything happens before then, we'll be back to talk about that. If you have not, some people are talking about their notifications and not getting notifications. Sometimes if you hit unsubscribe and subscribe back, and then make sure you hit all, then you'll get all notifications. So that's the issue. That's a way that you can try that to make sure you get notifications that I'm live. I also posted in my stories. I try to every time, unless I just jump on Instagram. So you follow me on Instagram. That is a way to know if I am live. And also I did a video earlier. Make sure y'all run up them numbers. All y'all go over there and hit the like button. If you don't do nothing else, go over there and hit that like button over there on that video about Ernest Williams today. All right. And then we got into Later on in the video, we did discuss Cassie's impact statement, Deontay's impact statement. I think those were the only two that we went over, but yeah. All right, y'all have a good night, though. I'll holler at you later.